Grand Rising, everybody. This is Tarhaka Presents, and today we're going to deal with something that's very, very important. It's a part of our secure party and creditor thing that we deal with, and it is part of the bulwark of what we do. Today we want to talk about trust, and once again we be coming to you from our Black's Law Dictionary, and we'll be coming to you from the art of passing the buck to the blueprints. Okay? Now, I thought it was necessary to do this video today because this is very, very important. This is something that I think a lot of us overlook. The first thing I'm going to deal with is the definition of trust from Black's Law Dictionary. It states here, a legal trust, a legal entity created by a grantor for the benefits of designated beneficiaries under the laws of the state and the valid trust instrument. The trustee holds a fiduciary responsibility to manage the trust corpus assets and income for the economic benefit of all the beneficiaries. Okay? A confidence repose in one person who is termed trustee for the benefit of another, who is called the Seskike Trust, respecting property which is held by the trustee for the benefits of the Seskike Trust. Okay, and all your Supreme Court rulings and things are there. All right. Any arrangement whereby property is transferred with intention that it be administered by trustee for another's benefit, a fiduciary responsibility in which one person is the holder of the title of property subject to an equitable obligation to keep or use the property for the benefit of another. Okay, and your Supreme Court rulings are there. We're not going to go over the whole thing here, and we're going to get down into the mechanics of a trust. But let's take a look at something. This is very important, and this is what I think a lot of us overlook. In the art of passing the buck to the blueprints, states the following information. Education of the heirs, okay, the beneficiaries. This is something we overlook. We want to set up the trust. We want to get the trust manager. We want to get the trustees. We want to get the trust secretary, trust protector. All this is on the benefit of the beneficiary. But what about the beneficiaries? What is it that the beneficiaries should be knowing about the trust? I mean, after all, it's all being done for their benefit. All right, let's take a look at what it says down here on page 4. Education of the heirs. Through involvement in trust management, the children, as heirs to the family fortune, become properly educated to prepare for their new roles in the trust. Now they are beneficiaries and have a stake in its success, showing them how to create a deposit slip, pay the bills, or have them included in the board of trustee meetings can work wonders. As this happens, you will likely see a surge in their respect for themselves and others, their willingness to pull their weight and chores and other duties, to complete their schoolwork and ask for more. Being included contributes to their maturity, becoming worthy beneficiaries and potential trust officers. Now, this is something that a lot of people has established in their trust. And I'm here to tell you, because I deal with people that are secure party creditors all over the United States and other countries. They have gotten our secure party creditor packages from us, and they are putting their trust together and stuff. And when I ask them about how the beneficiaries are doing, oh, they're doing just fine. They run around and just playing. Okay, well, what about, tell me about when you included them in the board meetings and begin to show them how this trust functions and what you are doing. So I just wanted to bring that out because it's very, very important. Daily responsibilities. The grantor can be the driving force behind the trust, but needs administrative and sometimes moral and emotional support from the trustees, other officers, and family. They are not only serve as his or her advisors, but shoulder some of the duties of managing the family. Many times the grantor proves to be a problem. If he or she becomes involved, the grantor may still believe this is a personal pile of cash and forget he or she gave it away or added it to the trust. But anyway, that's what I want to point out to you. And one other thing that we do, I think that we should start taking a look at. And I gave this information out at the Marcus Garvey weekend here in August a few years ago down in Fernandina Beach. You, during your lifetime while you're still alive, I think it's an excellent idea that you give your children at least part of their inheritance while you're still alive. Instead of waiting until you pass away, you got the will going and you got all of this here stuff going, and we're going to leave this for you and that for you, and if you have a will set up or cases going down in probate court, people fighting and all this stuff, instead of setting up a trust and take your will and put in that trust. If you got a grocery store, or if you got a convenience store, or automobile, or land, or whatever you want to have, put it in your trust. If you got lesser trust, you can install one trust into another trust. Okay, and you do all these things. But give your children at least part of their inheritance while you're still alive. I just wanted to add that little bit there. Now let's get on down into trust. Okay? Let's go, y'all. Okay, everybody. Now, in a lot of cases, when you're establishing your trust, there may be times when you run into assets and items that somebody wants to give you or something of that nature, and you want to assign it to your trust, and this is coming from one person going to another. This is a copy of a durable power of attorney, and this comes along with our secure party and creditor package. You can use this in every case that you have when you have the transfer of assets from one individual to another. In other words, if your let's say your uncle wants to leave you land, if you want to leave you some cash, silver, or gold, or automobiles, or clothing, or whatever it is that he wants to give you, you can record this information on a durable power of attorney, have them sign it, and make sure you keep this among your records. You can get it notarized and dated, and that way you have all the necessary documents you need to get this going. We're not going to read the cautionary information. It's been there sitting there long enough for you to read it. But let's get on down into the meat and potatoes of this thing. Known by all persons present that John Doe, 1234 Jackson Street, Jacksonville, Florida, 32208, principal, execute this durable power of attorney and do hereby make constitute and appoint Tarhaka Monreal Bay, P.O. Box 9686, Jacksonville, Florida 32208, agent and attorney in fact, as my attorney in fact to act in my name, placed instead in any way which I myself could do, as if I were a personal present, and to the extent that I am permitted by law to act through an agent pursuant to the following provisions. Okay, this is this document goes from you to another person, and I mean from one person to you, whoever you are assigning something to. If someone is going to pass away, or someone you can something, you can have them do up a doable power of attorney and assign what assets they want to assign, and all of this information should be placed down in this particular document. I'm not going to go down through this whole thing, but I only want you to know the tools that you should have available when establishing your trust to administer your estate. Okay? All right. let's go on to the next document. Now, I don't know if you've ever seen this document before, but this is the Matrix and the U.S. Constitution, author unknown. We have used certain parts of this information in here very, very successfully. In fact, we use it as early as about 2 years ago, where we was had a situation where an attorney was trying to take some property from a friend of mine, and he was able to extract the information from here and use it very, very strategically, and it worked just fine. He has his property, everything is a-okay. But it's something in here I want you to pay attention to. It says, let me explain how the court arrived at its ruling. Now we're going to pass on that. Let's go to the next paragraph down here. The sovereign states had been abolished in 1790 by the adoption of Article 1 of the Statutes at Large, which converted all sovereign states into federal districts and gave the federal government lawful jurisdiction everywhere, in consideration of the fact that the federal government is a corporation and that corporations can lawfully own other corporations, and all the American subjects to be educated have admitted under penalty of perjury that they are corporations. Wait a minute here now. Yeah, right there. The Supreme Court ruled in favor of the corporate federal government. See how sneaky and tricky lawyers can be? And all the more reason why lawyers should never be allowed to serve in government or in judgment of us. Okay? Under our corporate government, no sovereign can lawfully be tried or convicted of any statutory crime. Read this again now. Under our corporate governments, no sovereign can lawfully be tried or convicted of any statutory crime. Now, in this case, what are we talking about? We're talking about a man and a woman, ain't we? I recently discovered how to avoid prosecution under the trust when a sovereign is taken before a corporate prosecuting attorney or judge. I'm talking about a man and a woman now. We're not talking about a sovereign citizens or none of that kind of crap. There's no such thing as a sovereign citizen. You can't be a king and a subject at the same time. Okay. First, the sovereign must inquire if we are on the record. That's step one. And if not, insist upon it. Say nothing, sign nothing, and answer no questions until you are convinced that the proceedings are being recorded. Okay? I try to tell people to stay out of the state coast. Stay out of the boo-boo house. Don't get in there. Secondly, I got to get rid of this word sovereign. All men and women had to say for the record is, I am a beneficiary of the trust, and I'm appointing you as my trustee, talking to the judge. The man or woman then directs his trustee to do his bidding. As my trustee, I want you to discharge this matter I'm accused of and eliminate the record. Fourthly, if the man or woman suffered any damages as a result of his or her arrest, he can direct that the trust compensate him from the proceeds of the court by saying, I wish to be compensated for X amount of dollars in redemption. This statement is sufficient to remove the authority and jurisdiction from any prosecuting attorney or judge. The accused will be immediately released from custody with a check, license, or claim identifies as damage. It doesn't matter what the action involves or how it is classified. By the corporate law is a civil criminal action. It works every time. But anyway, this is all part of what should be going into your declaration of trust. When you create your declaration of trust, if I were you, I'll do what we did. We gave out a copy of this document not only for the trustees and the trust secretary, but also for the beneficiaries to have a copy of this thing as well. Okay, And these are the two documents that I wanted to bring out for you. And we're moving toward the close of this thing. So we're going to stop right here and go on to the next thing. Okay, y'all. One other thing that we want to take a look at, and it's called Common Law, the Facts. Common law is the beginning of all law, and in its perfection is the absence of all law. And in today's society, it is known as public policy. Common law, summed up in simple terms, is the will of the people and will manifest itself in separate cases as people so rule with their conscience and in a sense of fair play. Common law is a law that is common to all people. Common law is common sense and is the law of the creator of this universe. Do unto others as you would have them do unto you. Common law supersedes all law and is superior in all cases to statutory law, codified law, and rules and regulations. Common law established constitutions as all power is inherent in the people. I'm not going to get down into all of this, but I suggest that you get a copy of this. This does come along with our secure party and credit package as well. Very, very informative and very important for you to know. Okay, we're going to go on to the next step. I'm not going to get down to this at all, but this does conclude some heavy artillery for you to have in your possessions when you are establishing your trust. This is Parkinson's handy book for the common law judges' chambers, and this does come along with our little secure party creditor package as well. I'm not going to get into it at all, but you'll be able to do this at your leisure, and this makes for very, very a strong understanding of what you're dealing with and what's going on inside the United States. But I'm going to go ahead and shut this thing down now and bring this stuff on trust to a conclusion. I think there's an insert that we may put in there so somebody can explain to you about trust. Instead of me doing all this talking, I'll just add a little audio presentation into this today's segment, and you'll be able to get a hold of that. Okay? But anyway, let's conclude. Okay, everybody, this concludes our presentation for this morning, and I hope you got something out of this. And keep in mind, this is very, very important information, and you can get a hold to us at tarhakadebtelimination.org. That's tarhakadebtelimination.org, and you can contact me. My contact information is there. We answer the phone. We're available from 9:30 a.m. Eastern Standard Time until 6:45 p.m. Eastern Standard Time, 7 days a week, and this includes all American holidays where we don't participate in any of that. However, because we take care of business. But nevertheless, this information is extremely important, and I would encourage you to subscribe to our channel over there on YouTube. And give us a thumb up, and that helps us spread this information. And make sure you contact us. You can get my free report just by filling out the contact us information on our tarhakadebtelimination.org. Just fill that out. That comes to me. I'll automatically send you our free report straight to your email address. Okay? But we're going to conclude. And once again, I hope this has been helpful. I'm Tarhaka. I'm on LB. Y'all have a good day. Grand rising to you.